Welcome back to Property Auction Hunters. Today we are deep diving into the legal side of property auctions with a very special guest, David Burns, a litigation solicitor and partner at Ronald Fletcher Baker Solicitors. And if that's not enough, he is a jiu-jitsu champion, a keen cyclist, and a member of the Auction Buyers Club. If you've ever dealt with legal challenges in property deals or worried about the potential pitfalls, then this is the episode for you. David is here to share invaluable advice on how to navigate legal disputes, but most importantly, how to avoid them altogether. Whether you're a seasoned property investor or just starting out, understanding the legal landscape is crucial to your success in auctions. Plus, stay tuned to the end where we will tell you about an exciting opportunity to join us and several other real-life property trading experts at our mastermind retreat in Portugal.
Today we have a special person with us, a litigation solicitor, a person specializing in landlord and tenant act and all kind of legal issues and litigation issues. And today we're going to be talking about how to resolve issues, the legal issues that arise, and also, I think most importantly, how to avoid them, right?
Yeah.
But David, do you want to introduce yourself a little bit, just so that everyone knows
Yeah.
who we're dealing with?
Yeah, my name is David Burns. I'm a partner at Ronald Fletcher Baker Solicitors, and as you say, I specialize in disputes, so litigation relating to property, often auction-related disputes, as you mentioned, commercial landlord and tenant, residential landlord and tenant, and sort of real property boundary issues, and a little bit of commercial disputes as well that offshoot from that.
Brilliant. Well, I think from the time we know you, I think that's like 8 years, 9 years. We've gone through quite a lot of cases and all kind of varied degree, like from like tiny little annoying things to quite big things that can have potentially big consequences for all parties. So, can you give us a bit of an example of the variety of things that you deal with on a daily basis?
Yeah. So I suppose I was just speaking to my colleague there a moment ago about a case we're dealing with last week, which involved an auction property where two buyers, a young couple, purchased what they thought was a leasehold property with a ground floor shop operating, and that they were going to get the rent from that, which was a decent yield on that. And they found out that in fact that property was freehold. So there was a long lease already in place, and it was very little ground rent, and so they've effectively purchased
a ground rent investment.
Which they thought wasn't going to be the case. So we've now served the letter before action on the sellers for misrepresentation. The actual auction pack itself mentioned that the thing for sale was a leasehold property, and in fact it was the freehold. Now, had the buyers probably went through the auction pack with the solicitor, they probably would have identified this, but they bought it without any advice, and so now we're involved, have served the letter before action, and we should be receiving a response in about 2 weeks to that. But that was one that just came up last week, and then endless amounts of disputes. Probably a few involving lease extensions that relate to properties, which I know you've been involved with a few of those.
Yeah, we love those.
You love those. I had one not so long ago where someone had served the seller had served a Section 42 notice already on the landlord and put it into auction, and the 42 notice was served at a proposed premium of, I think it was 35,000, and so the person bought or exchanged properties at auction, again without legal advice, and it turns out the notice itself was invalid for various reasons. There was, they hadn't complied with the requirements, but also when we obtained the actual valuation from Andrew, it was closer to 300,000. It was the actual premium payable. So,
I mean, we see a lot of these where it's not reasonable, but let's say they put the notice down at 35,000.
Yeah,
you're probably looking at a £70,000 extension, but 35 to 300 is it's demonstrable. It's
well, and the difficulty in that one was that it was a trader, and the solicitor who acts on behalf of several traders had added in a comprehensive disclaimer saying there will be no claims arising out of this notice, even if it is completely wrong and invalid,
Wow.
there's no claims against the seller, almost as if they may have been aware that
they're trying to cheat someone by just presenting something that they know it's not going to be good.
Well, exactly, yeah. And I think that's what the buyer had thought in that case. He thought maybe 70, 80, whatever, but it's still a good deal even at 100k, not at 300,000 for the premium. It's a 2-bed flat in North London.
Because your general due diligence would be, if you think it's 80,000, you're going to budget your maximum bid with that in mind. If you have no perception that it's going to be 300,000, then clearly you're going to overpay.
Exactly.
So there's a tangible loss there. There's a misrepresentation.
But also you'll get ones where, in fact, the solicitors have done what they believe to be a good job, and there's no misrepresentation. They've put a reasonable premium in, but there's still some sort of technical error in the 42 notice. And if there is any of that, then you're going to have to wait the 2 years to establish qualification. Hopefully that's going to change in the next,
with the new law,
with the new legislation that's received royal assent, but we don't know when yet.
So I've got 2 questions for you.
Okay.
That will be good questions, I promise.
Okay.
The first one is, what are the top 5 main areas that you find that people have when they're buying a property at auction, when they haven't sought legal advice in advance? And then what normal advice do you give to clients that do get the legal advice in advance, where you solve the problem before it's a problem, or you identify the problem so they can mitigate their maximum bid to allocate for that issue?
Mm-hmm. So top 5, probably the top one would be similar to what we just had last week. So people buying things or being mistaken about what they're buying in some way. So either it's a freehold or a leasehold, or they just don't like the thing they've bought. They haven't properly looked into it. I know when we were at one of the events where David Sandeman was talking, he mentioned that about 40% of people don't read through the legal packs.
Yeah.
And that seems to play through from my experience, because so many people are surprised at what they've bought sometimes, and they're like, well, I want out of this, David. How do you get out of it? Give it back. It's like, well, it's not that straightforward. We can look at this, see if there's misrep or whatever, but if there's not, you've already exchanged contracts at auction. So probably number 1 would be not fully understanding what you are buying or what they've bought. Then number 2 is probably issues around legal technical deficiencies with either short leases or properties that, for example, required service of Section 5 notices under the Landlord and Tenant Act, and those not being done properly, and issues arising out of that. A third one, which is one that's come up a few times recently, I know you guys are probably aware of this, is people agreeing to purchase properties in auction, but in the special conditions of those sales, there is a provision stating that the seller doesn't actually own the property they're selling, but have, for example, entered into a share purchase agreement to buy the shares in the company that will ultimately sell the property. And that just creates a recipe for a lot of stress and anxiety and things that could potentially go wrong. And another one I've seen sneak into some special conditions in auction sales is around, let me see, a seller stating that they have a right at any point up to completion to rescind the contract.
Yeah, the have your cake and eat it clause. If they don't like the price, they repudiate the contract. So not even rescind, they just pretend like the contract never existed.
It just, exactly. They can terminate it. And the problem with that is I've seen clients where they've been at auction, they've been a successful bidder, hammers went down, and they're going through the legals, and then they see that property back in auction again in a few weeks' time, and so they're obviously panicking, thinking what on earth's going on. And sometimes they'll make a judgment call and say, well, I'm going to rescind the contract because this guy's breached the contract, he's selling the property I've already agreed to purchase, when in fact he has a contractual right to do so under the special conditions.
So that's like a reverse option where they have an option to complete if they want to, or
Exactly.
they don't. They just sell a property and
Yeah.
they don't.
And I have seen that conjoined with the clause where they're also permitted to, or they're not the actual owner of the property. And so you've got this situation where they don't own it, and they can pull out at any time. They're sticking it into other auctions at the same time. So then you've got a buyer who's going to not, who's definitely not going to feel comfortable, because you're going to have to line up your funds, etc. Anyway, you're going to have to probably, if people are doing bridging or mortgages, you would have to have that drawn down in advance of the completion.
So it's like the whole transactions in the hands of the seller, who can do whatever they want, and depending on what they do, you have to respond to it quickly enough. So
exactly.
very uncomfortable.
Very
So
uncomfortable.
on this point, we had someone in our auction buyers club, must have been in the club for 18 months, 2 years. Rarely attended a call, would come to our boardroom meets just because it's a good social event. Called me up one day, and I was on my way to the Property Investor Show in London. I picked up, I said, great to hear from you. What are you looking at? He said, I'm going to send you the link to the property. I want you to get me this property, but I want you to, there's so many fees in the legal pack. It's like £20,000 worth of fees in the legal pack. And I think it was around a £400,000 purchase, just rough numbers. And I remember referring him over to you because once we got all of those fees cut out of the legal pack, barring £1,800, and I told him about there's this clause and there's this clause. These are things that you have to be careful of. But it was quite fortunate because you knew who his acting solicitor was, and you guys were able to work through that. And actually, the seller, not the ultimate seller, but the person selling to this chap, tried to resell it like 6 or 7 times within the completion period, which is remarkable.
Yeah, I think part of the trick with that case was actually not doing anything which harmed your own position, because so many people, when they see their own property being advertised 6 times, or well, the property they've just exchanged on, they want to take action and either attempt to rescind that contract, which could potentially then leave that client exposed to a claim by the seller for unlawfully rescinding the contract and damages that flow from that if it was then sold for a lesser amount.
Yeah.
So we had to be really careful about how we dealt with that, and eventually got a really good result in that.
Yeah, he secured it, and the really great thing about that is that he didn't think it came with the car park.
Yes.
But the seller, upon a completion, as part of the transfer deeds, didn't hive off the car park.
Yes.
So legally, they had to sell that whole title to him. So they got £18,000 removed in fees.
Yeah.
They had how many aborted sales in between. He just stood still, carried on, and just said, I'm here to do the deal, which was probably the best thing for it.
Yeah.
And he got a car park for free, which he didn't think he was getting. So
he
it was
did
a really
well.
good deal.
He did very well out of that one.
A very good deal.
There was actually, in the topic of good deals, another one, instead of just telling horror stories, so is around absent landlords. Because I've found a few clients who have been able to get good opportunities in those situations, or make an opportunity for themselves. Because if there is an absent landlord, there's a procedure around attempting to find the landlord, going to court, applying for a vesting order, and then if you can satisfy that part of that stage of the claim, then you go to the tribunal with your surveyor's proposed premium, which they will consider. But there won't generally be, there won't be a landlord or a surveyor making a counter proposal that's usually significantly higher.
Yeah.
And so, in a few cases that we've dealt with, we've got a really good premium agreed and approved by the tribunal. We've also managed to, and you don't get this in every occasion, but we've been able to have the legal fees reduced from that premium by way of an order from the tribunal.
Wow.
And also we managed on one occasion to have an order that it was a 2-bed flat and it was on the upper floors, and we managed to get a declaration that the lease included the loft space. Which
so you could like mansard and stick an extra room.
Exactly. Yeah. And so it ended up being a brilliant, and then we went back to the court and we got the order, paid the money into court for the landlord to pick up if he ever does show, or she ever does show up. And he got a blinding deal. And that's happened where we've had a few absent landlords. Another one where a lady had a long leasehold interest, and there was a leasehold interest above hers, an intermediate one, and they dissolved. There was a 999-year lease.
Okay,
And so,
style.
yeah, and so the property wasn't really being managed by anyone at that point. And so we made an application to court for that long 999-year lease to be vested in our client.
Oh, wow.
Our client had it. And so we got it for no premium.
Really?
Yeah.
So it's like another flat, kind of?
Not another, but it was like previously it had been like a 58-year lease or 59, something like that. And so now she had the 999-year lease.
Wow.
It's funny, she actually came, that was a few years ago, and she just recently came to sell it. And she came and said, "Oh, what did you guys do for me? Because now I've got these two leases. I don't know have you done this right? Because now I've got two leases." I'm like, "Yeah, you've got a 999-year lease." Now you're like, "We did a great job for you. You can give yourself a long lease extension for free now." So.
Yeah.
Wow. And is it possible to also like actually buy the freehold if there's a missing absentee freeholder?
Yeah. So it's similar provision. You can either extend the lease or do a similar process, but as long as you've fulfilled the qualifying criteria and you've got the other tenants that are willing to participate, then you can do a similar procedure.
But it's very prudent that you bring this up as one of your 5 main issues that you come across at auction, right? Because we have a client who bought a property from auction, absentee freeholder, so missing landlord, has done a tracing search, found them, they're nowhere to be found. So he will want to be going through that vesting order process because he got himself a blinding deal. The property is in northwest London, a part of town. Bought it from one of the modern method sell auctions. So bought it in absolute steal. It's just brilliant location. Don't really need to do anything internally to the property. It's in good condition. The only thing that's affecting its value, mortgageability, is this absentee freeholder thing. So we'll send him this video and say, this is what you need to do. You need to speak to David.
Well, I think I may have already spoken to him.
Yes.
Yeah, I think I have. I know who you're talking about. Also, with those, it might be the case that he could benefit even further as a result of the upcoming changes. So obviously the changes to the Leasehold Reform and Housing Development Act 1993 have received royal assent. But it's going to come in, well, we don't know actually exactly when it's going to come in, but we anticipate around 18 months' time or something like that.
Yeah.
And so then he shouldn't have to pay at that point if he held on to then. There shouldn't be any freeholders' legal costs to pay either. So yeah, I think he'll probably do quite well out of that.
It's a strong rental area, so as long as he can hold his breath and get it rented and just hold it, I think it's a stunning deal.
There's actually two. You have another Auction Buyers Club member who's got a similar situation as well. Who's called me recently on a purchase of a leasehold flat, and they've just found out that they think the freeholder hasn't been insuring the property for years. So she purchased. She says, "Hang on, who is actually insuring this property?" And then after some investigation, I think they've realised that the freeholder is in administration.
I see.
So there could be fun and an opportunity there for her as well.
So I mean, the second question that I asked.
Oh yes.
What do you see most commonly that you pick up in a legal pack, and then you advise a client, be wary of X, Y, and Z. This is what it could mean. Like apart from like the things that you've saved and salvaged after they've exchanged, which is not ideal. But if a client comes to you beforehand, what things have you pointed out and said, you know what, that might be an issue, maybe reduce your maximum bid by X to account for additional cost or time to hold to resolve those issues?
So for some reason, most people come to me afterwards. So the other guys you'll speak to, Ali and John, they deal a lot more with the previous, pre-auction stuff. But the few that do come to a litigator prior to actually offering, one that we see is around sometimes where you've got mortgagees in possession and the tenancies in there are vague or just not known at all.
Yeah.
So you may have just no agreements whatsoever, either with commercial tenants or residential tenants. And so then there's going to be, we can look into, well, what is the potential route to get secure in possession of this property? either for commercial or resi. Sometimes it can involve, practical application. For example, some people just knocking on the door and going down there and seeing because if the tenant, if the mortgagees in possession just won't give you any details of the tenancy, and we don't even know if there's any arrears, and we don't know if any of the prescribed information's been served, in order to allow a 21 notice to be served on the occupiers, then it's difficult to, you'd certainly have to factor in that risk and the time element, the delay, because as you know, these with commercial and resi tenants, if there are ongoing breaches of the leases or irregularities, they're not using it as they should be, what tends to happen is it just slows down deals. Because people don't want to get involved in litigation if they can avoid it, probably rightly so. You avoid me at all costs usually. And so you guys know from your own experience that those types of difficulties with tenants that are already in occupation, that's probably one of the most common things that I'll discuss with people that come to me before they buy properties, I'd say.
I think those things are like best handled, like actually that's how I like to handle things best. It's like actually in person speaking to someone and actually resolving things. But I guess litigation solicitors are needed to have that threat hanging over someone that legal things can be pursued, and also knowing the structure of what would need to actually happen for things to be resolved.
And probably to set out like a worst case scenario for someone who's considering to bid. Could you be stuck in this for 18 months to 2 years? Have you got that?
And also the best deals where you are aware of the worst case scenario, you prepared to bid up to the amount which takes into account all the costs required with this worst case scenario, but then you win it and you actually 90% of the time are able to resolve things before that worst case scenario actually happens, and then those are the best deals.
I know some people who deliberately target, for example, regulated tenancies, and they're able to turn what most people would just accept as being a regulated tenancy into a property that's actually occupied by an AST tenant.
Well, we had that recently in the club as well. That was a really big success for one of the members. And they bought it wholly expecting it to be a reg and to hold it as a reg. And then when they found out it wasn't, it was kind of like, well, they've now released that value that was locked into it being a reg.
But they are specific. Not everyone can do that. There's some people who are very, very good at being able, they know that area really well, almost to the level of a solicitor specializing in that area, so they can spot the subtleties. I wouldn't say everyone go out and start buying regs and hope you're going to land on ASTs. But some people know really what they're doing in that area.
But that was the case with this client. She was basically buying knowing this is a reg. At the price where it works as a reg. And then if things work out better, then you have like 60k, 70k uplift, which you can realize almost immediately. And those tenants are moving out, I think, next couple of months.
Of their own volition, actually. So she really didn't have to do a great deal of work with it. So it's turned into a brilliant deal.
And those regulated tenancy things are less and less common because they're like so old and not really given.
And it probably puts quite, apart from the people who don't know what they're buying, which has happened, before again. A lot of people are sort of put off by the regulated tenancy stuff because it's just a bit, it's if they are regulated tenancies, obviously difficult to then, to get possession. Unless, I know you've mentioned before about checking the profile of the regulated tenant.
The value is all tied up in the profile of the tenant. As try not to be as morbid as possible with it. But going back to your point about mortgagees in possession and mortgagees not in possession, we saw a whole spate last year. Just a quick final point. Well, obviously the receivers, the LPO receivers, they wouldn't disclose the nature of the tenants, any tenancy agreements in there. And we saw rumour on the grapevine that a lot of these properties were being sold with the borrower creating their own either lease or AST to frustrate the sale. So there's those things as well to consider.
Yeah.
But no, brilliant points, David. Thank you
No,
very much.
thank you for having me, guys. It's always a pleasure.
Yeah, definitely. And it's nicer circumstances than normally when there's an issue.
Yeah, exactly.
David, what will we do? How do we fix this?
Start by paying this invoice, boys. We'll talk about it after that.
Exactly. I'll
Always
send
done
you
with a
my
smile.
invoice for this.
Yeah.
No, that's brilliant.
Perfect. Thank you,
Brilliant.
guys.
Thanks.
Cheers.
Cheers.
That was an insightful conversation with David Burns, filled with practical advice on handling and avoiding legal issues in the property auction space. If you are interested in diving deeper into property investment strategies, we would love to see you at our Portugal Trading Mastermind Retreat. If you are interested to hear more about how this could skyrocket your property trading activity, make sure you click on the link in the description and set up a call with us. It is the perfect opportunity to network with investors, learn from the best, and gain insider knowledge. Don't miss it. And of course, if you've enjoyed today's episode, don't forget to like, subscribe, hit the notification bell so you never miss an episode and an update from the Property Auction Hunters. Join our community and take advantage of our knowledge and take your auction game to the next level. See you in the next episode.